Thank you. I'll now ask my questions. Mr. Mayor, since the Obama administration, the board has made some pretty severe policy swings, and I gather it's been difficult for workers and other stakeholders to understand and comply with the law. In our personal conversation, you spoke about that complexity. So can you speak to how creating stability and predictability in labor law helps workers? And if confirmed, how would you work to improve compliance with labor law?
Thank you, Senator. The law, wide swings in the law aren't good for anybody. In my opinion, from the standpoint of advising employers, stability is important and understanding the rules of the road are important. As I said in my opening, my experience has been that most employers simply want to treat their employees well and comply with the law. And I truly believe that. Where employers have to change their policies or their handbooks on an occasional basis because the National Labor Relations Board or another agency engages in some adjudication that changes the law is somewhat disruptive. So the goal is stability in the law. And that helps all stakeholders because they really understand all the rules of the road, and that includes not only employers, but all employees and unions.
In our personal conversation, I think either you or Mr. Murphy mentioned how a small, medium-sized business whose workers want to unionize can make a mistake, run afoul of the law just because sometimes the law is counterintuitive. Is there any way to address that? Because, I mean, you want to do the right thing and you get slammed legally because there's a law set up and you're thinking, why in the heck did they do that law? But you only say it after you violated it. Mr. Murphy?
That's correct, Senator. It can happen. Unfortunately, the board can't issue advisory decisions. I do believe that parties could reach out to a regional office and at least get some guidance as far as what they should be doing in a particular situation.
But if you're a small, medium-sized business, I guess you need the attorney to tell you to reach out.
That is a problem. Yes, sir. It's a legal issue and it would probably have to go through legal representation.
And I think you, Mr. Mayor, spoke of the EEOC as having one standard, and the NLRB having a different. The first Trump administration tried to reconcile the two, and this is about calling people names. The issue in particular was using racial epithets to call somebody, which clearly should be forbidden by EEOC, but somehow got protected under NLRB, and the employer has to decide which law to break. And I gather that reconciliation under Trump 1 was reversed under Biden. You want to comment on that? Because that just puts the employer in aside from the fact that calling racial epithets is wrong.
Well, I'll talk about the current state of the law, Senator, and how it developed, but I can't really speak about issues that could come before me should I be confirmed. This is an issue about whether an employee who's engaged in protected concerted activities has additional protections under the law if those, if the comments or the conduct they're engaging in violates Title VII or some other federal or state law. Prior to the Trump board, there were a number of situation-specific standards that gave additional protections. That was challenged, and in the General Motors case under the Trump board, the EEOC actually weighed in and said, hey, employers shouldn't effectively have to choose which law to break, and issued the General Motors case. That was reversed under the Biden board in a case called Lyon Elastomers.
I would say that's a case history of why don't we give stability of law to work to employers so they can do the right thing by the employees, just to say. Mr. Palmieri, given your experience in the first Trump administration implementing the Foundations of Evidence-Based Policymaking Act, please describe how you'll incorporate stakeholder feedback in the regulatory process.
Certainly. Thank you, Chairman. I think that was a great work of bipartisanship in the first Trump administration, and I think evidence-based policymaking is truly a bipartisan concern. I think in the regulatory process, we've always had the Administrative Procedure Act to guide us in incorporating stakeholder feedback into our regulatory policies. I think the Evidence-Based Policy Making Act also gives us a chief evidence officer at the Department of Labor, which is in the Office of Policy, to help us ensure that the research work and the data that we're gathering can be utilized in supporting the regulatory policies and choices that we're making. So I look forward to working with you and the committee in furthering those efforts as well.